such that they can be deemed a civilian population for the purpose of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassam confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole, and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole, or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own
Shoutout sa'yo, Ma'am
witnesses,
Sorina.
who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court?
Tama.
After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, take too long for the penny to drop. As I mentioned in my opening statement, prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out, pulled the trigger, or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's
Tinamaan na po yung
and the deaths pertinent to the
yung
case.
dalawa to mga kabayan na tama po,
That would
no?
have been ordering. And
May laman po yung sinabi ni Attorney Kaufman, mga kababayan.
But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing the screenshot, but there you have it. That is where the apex slips off the Pyramid of Giza. The most they can do is allege that they're cooperating witnesses who pulled the trigger and whose credibility is about as
Magandang hapon po
worthless
sa ating lahat,
as a
mga kababayan, na
devalued
magandang gabi
peso.
po.
Understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case, and that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone.
Yes, tama.
Let us just digest this.
Trending na naman to, mga kababayan.
All those speeches,
Trending naman to yung sinabi po ni Attorney Kaufman.
various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability as pleaded contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte, or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents will not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability leveled at Rodrigo Duterte.
Grabe mga kabayan, no? Punto por punto talaga yung sinabi po ni Attorney Kaufman.
As we all know, in order to prove criminal
Hindi
liability,
po chismis yung mga sinasabi po. Tumbok na tumbok po ni Attorney Kaufman, no?
common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was in addition wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33 inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else.
Grabe.
Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data.
Makapanindig balahibo mga kababayan yung sinabi ni Attorney Kaufman, no? Tumidig yung balahibo ko.
Is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances.
Siguro po, Ma'am Surina.
With a degree of certainty which reaches more than a substantial degree of certainty is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Interviewee, at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer, yes sir. Interviewer 1, okay. And on those 10 occasions, was the shooting justified? Interviewee, yes sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns. And they were pointing them at the pusher-buyers. Or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCP. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, that any one of the unreliable insider criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims. The prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of these so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
Ito mga bayan, oh, napansin ninyo, naging ganito po kapag si Attorney Kaufman na yung nagsasalita, biglang naging no broadcast. Yan, oh. May oras pa po si Attorney Kaufman para magsalita, pero pinuputol po nila yung mga statement po, no, ni Attorney Kaufman. Yan, hindi natin alam kung ano po yung sinabi ni Attorney Kaufman ngayon. Kasi naputol po mga kababayan. Hindi siguro sila nakabayad ng internet. ICC, magbayad naman kayo ng internet. Bakit naging ganito? Pinasali nila ang mga dala-dala nilang baril. Yan, no? Hindi siguro nakabayad ng internet ang ICC, mga kababayan, no? Nagsasalita pa po si Attorney Kaufman, pero naputol. Naggurgur yung naggurgur ang internet doon sa ICC. Ano ba to? Kala natin sa Pinas lang yung mahina yung internet. Bring him home, Tatay Digong to Davao City at Attorney Kaufman. Yes. Pinutol, bakit kaya? Kapag si Attorney Kaufman na yung nagsasalita, biglang no broadcast po yung lalabas. Bakit kaya? Anong meron? Ano yung meron dito, ICC, ha? Napaghalataan na kayo, eh. Yan. Tingnan ninyo kapag yung mga nag-akusa, yung nagsasalita, mga kabayan. Pero kung kay Attorney Kaufman, yan, no, napakatagal. Alam na maraming tao ang buong mundo nanonood. Yun nga, bayad kasi ang ICC kaya walang broadcast. Ito yung mahirap sa kanila. Kitang-kita naman, mga kababayan, no? Yung mga ginagawa po nila, na lalong-lalo na itong mga nag-akusa po kay Tatay Digong, yung mga binabasa po nila, parang chismis lang sa gilid, no? Pang barangay lang po. Yung mga ipinakita nila, ipresenta nila mga ebidensya, no, ganun lang. Yung naghawak ng baril si Tatay Digong, ganun lang ba yung mga basihan po ng ebidensya para masabi natin na may ginagawang krimen yung isang tao? Napakaraming mga mga tao po na humahawak ng baril. Kahit nga yung dating presidente, yung ibang presidente, humahawak din ng baril. Yun lang na, no, parang ang babaw po talaga. Kami dito sa Italia, kahit nagtatrabaho kami, naka-headset, nakikinig, kaya nakakabuisit. Gimas Solatorio, wala na, sayang, oh. Hindi natin alam kung ano po yung sinabi ngayon ni Attorney Kaufman. May kumukontra kay Attorney Kaufman. Baka si usap na naman may plano para putulin ang pasasalan ni Attorney Kaufman. Ayan, oh.
And that is set out in paragraph 27. and mentions that on the very day that the former president appointed Ronald De La Rosa
Right.
Bato as the chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald De La Rosa Bato within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how Tok Hang means knock and plead.
You know?
That it is a totally legitimate police strategy.
Yes.
However,
Tama
the
yung sinabi po ni
citations
Atty. Kaufman.
relied on by the prosecution to infer that Tok Hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question: Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights? Answer: good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL, OTP 000 16403 at page 30.
Kulang na lang mga babae, no? Pagtuturuan sila tuturuin sila isa-isa po ni Atty. Kaufman, no? Para matauhan po itong mga judges na to.
And what it has not shown you, by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same command circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the command circular? After all, this command circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. If that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Captain, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that would be good. Thank you very much, says Judge Motok. We will take a break now and resume at
We'll
11:30.
take a break, mga kababayan. Siguradong matatauhan po itong mga judge na to. Yan, tamimi po yung mga... Grabe, napakagaling po ni Attorney Kaufman. Puro po katotohanan po yung sinabi niya. Oh, yan. Tapos na po, mamaya po ay babalik po yan sila. Mga kababayan, ngayong February 28, no, may live naman din po tayo sa ISD. Inday Sara Duterte 2028 movement, no. Abangan po ninyo ang ISD 2028 movement, no. May live po tayo diyan, no. Kasama po si dating Commissioner Mar Masanggid para po suportahan po, no, si BP Inday Sara sa 2028, no, ang ating pangulo, no, ng bansang Pilipinas. Kahapon may candle lightning, no, doon sa San Pedro, sa cathedral, no, sa labas po, San Pedro Street. At syempre yung pagdating po ni BP Inday Sara, first time ata mga kabayan, na umiyak si BP Inday Sara sa libo-libong tao, no, na halos puro mga leaders po yung mga nandoon, no, mga officials, na mga iski chairman, iski kagawad, barangay captain, barangay kagawad, mayors, nandoon din mga kababayan. Dating mayor, vice mayor, nandoon din kahapon sa may convention center, sa may SM Lanang. Grabe yung mga suporta. Mindanao, no? Hindi pa po kasama yung mga ibang-ibang lugar pa, no? Siguro yung iba ay hindi nakapunta, no, sa event kahapon. Sigurado marami pa yan mga kabayan, no. Buong Mindanao po yung pumunta, mga officials po, no, sa ginanap na event po kahapon. Palga ata, nakalimutan ko yung pangalan po ng yung meaning po ng palga. So yun, at magla-live tayo muli mga kababayan, magla-live tayo kasi ilang oras pa yan bago babalik po yung mga judges para tatalakayin muli. No, ito yung maganda kasi si Attorney Kaufman na nung nakarang araw kasi puro sila Yung sila Panot ata yun, yung nagsasalita. Ngayon maganda na kasi si Attorney Kaufman, maririnig na natin yung depensa po, mga kababayan, no. Makapanindig balahibo talaga, no. Kahit yung iba hindi natin na iintindihan, no, pero ramdam natin yung mga sinabi po ni Attorney Kaufman. Walang basihan, no, walang basihan po yung mga sinasabi ng laban po kay Tatay Digong. Lalong-lalo na itong mga ipinapakita nila, ipinipresenta nila mga pictures, mga video. Walang basihan po, lalo na yung sa Davao City na iniugnay po daw nila sa EJK. Pero hindi po yun sa EJK, mga kababayan. Parang, anong tawag nun? Kung hindi tayo nagkakamali, writing in tandem ba yun or ano? Pero hindi po yun, no? Tungkol po sa EJK. At yung mismong kumuha po ng video na yun ay nagsalita na po. Pwede po yung gamitin na ebidensya po laban po sa ICC at sa mga nag-akusa po dito kay Tatay Digong. Yun yung maganda. Kasi hindi po yun parang tawag nito, hindi po yan naugnay po, no, sa tinatawag nilang EJK. Hindi po daw doon yung video na yun. God bless PRD and Baby Sara Duterte and Duterte's family and Filipinos people. Attorney Kaufman, 5 Filipinos lawyer in ICC prosecutors, Lord, please touch all their hearts to dismiss case PRD. Ito yung mahirap lang, mga kabayan. Kung totoo nga, no? Ewan ko, di umano, itong sinabi ni Attorney Baligod at yung 18 Marines, no? Na yung lumantad, no? At yung pasabog po nila, yung mga ex-marines po na 18, at sinabi nila na meron daw $2 million. Tama ba yun? Hindi po tayo nagkakamali. Na para daw ibinigay po dito sa ICC. So kung hindi tayo nagkakamali, mismong yung Marines po yung nagsabi na may parte pala, no, itong ICC. Grabe. Pera po ng taong bayang winawaldas para lamang po siraan, mapabagsak ang mga Duterte. Ganon po sila kagahaman. Grabe, no, mga kababayan. Ilang bilyon na po yung kanilang nagastos para lamang pabagsakin ang mga Duterte. Ika nga ni Corina Sanchez, no? Dapat talaga malakas yung tuhod mo gaya ni BP Inday Sara. Di ba? Kahit anong mga paninira po nila kay BP Inday Sara, matatag pa rin po, no? Talagang matatag na matatag. Hindi po nagpapatinag kasi wala naman talaga silang mga basihan, no? Yung mga paninira nila pamumulitika talaga. At ngayon sinabi nila, pamumulitika po yung ginawa ni BP Inday Sara dahil nagpahayag at nag-anunsyo kaagad, no, na tatakbong presidente. Hindi naman sa ganon, no. Nasa sa kanya yan, depende sa tao sila pwede din naman silang magsabi, mag-anunsyo na tatakbo sila, no, sa pagka-presidente or maaga silang mag-anunsyo. Ito yung kabaliktaran or baluktot na utak po ng tawag nito. Pasensya, utok, Bisaya man ang utok. Yung baluktot po na utak nitong mga kampwet, mga loyalista nga at itong mga dilawan. Kung mag-anunsyo po ang mga Duterte na parang last na talaga or matagal mag-anunsyo, babatikusin nila. Ngayon, nag-anunsyo si BP Inday Sara ng mas maaga pa, no? 2026. Babatikusin na naman nila, sasabihin nila, pamumulitika. Talagang, napakawalang hiya po talaga, mga kababayan, no? Saan kaya yung utak po ng mga nambabatikos po sa mga Duterte? Lord, Lord, please bring back home PRD now in Jesus' name. Amen. Yes. Jumalin Lactao. Shout out po sa iyo. Sa lahat po mga kabayan sa mga nanood ng ating live ngayon. Alam kong yung iba talagang naiintindihan po nila. Alam ko sa kon pa lang ni Attorney Kaufman, sa mga pananalita pa lang po niya, sa pag-deliver po niya, ramdam mo na yung katotohanan talaga ay nasa panig po ng mga Duterte. Hindi po, wala po sa panig ng mga kalaban. Kasi yung kapag nagde-deliver po, no, ang mga kalaban na ng statement, marami talaga yung mga nagre-react. Katulad dito, puro hearts po talaga yung lumalabas. Mga reaction po ng mga kababayan natin na nanonood, puro hearts po. So, it means na talagang naniniwala sila, no, na itong pag-akusa po nila kay Tatay Digong ay wala talagang basihan. Itong mga tinatawag nilang EJK, sila-sila lang po. Sila-sila lang po yung mga nagsasabi ng EJK. Pero yung karamihan, no, overall talaga, wala naman pong EJK. Yung iba lang, talagang ginigipit po nila ang mga Duterte. Lalong-lalo na yung mga makabayan black. Yan mga kabayan. Itong mga makabayad black. Ngayon, lumitaw na po. No? Na yung pagbulgar po ng 18 ex-marines. Oo, nandoon na. Si Laila de Lima, kung di tayo nagkakamali, sino to? At yung iba pa, si Soto pala, mga bayan. Pinangalanan doon si si Tuta Soto, no? Pinangalanan po. Grabe, mali-malita na pera. Paano kaya nila ginagastos yung ganun karaming pera mga kababayan, no? Hindi pa ba sila na kontento sa daang libong sinasahod po nila buwan-buwan? 200 to 300,000 kada buwan po yung sinasahod nila. Hindi pa ba sila kontento sa ganun? Tayo nga, 20,000 to 30,000, napakalaking halaga na yan, no, na sinasahod natin kapag nagtatrabaho tayo. Sila, mali-malita, no, na ang laman po ay milyong-milyong pisong halaga po ng pera. Grabe. So, yun, at magpapaalam na po tayo, magla-live tayo muli, no, pagbalik po nila mga kabayan. At hanggang dito na lang, no, huwag po nating kalimutan, BP Inday Sara, malapit na 2028 ang ating Pangulo, ang ating Presidente po ng bansang Pilipinas. Maraming salamat po. God bless po sa ating lahat.